Hey TikTok, Family Law Mama, and I am back about the 3 ways to avoid talking directly, communicating directly with your ex or your co-parent, just because that can be a source of so much tension, especially when there has been a history of emotional abuse, financial abuse, especially, any kind of domestic violence. It's really stressful, and I get that, to continue talking to the co-parent. So I've gone over that. Number one was the suggestion that you use the apps, either Our Family Wizard or Our Talking Parents or something like that. And if you just prefer to use text and email, you can do that, and that can even be court ordered if that's the best way to communicate. The second way that I mentioned yesterday, number 2, was to use a parenting coordinator. There are only certain states that recognize those, but if you're in a state, if your case was filed in a state where parenting coordinators are recognized, then you can request a PC or a PCDM, either a parenting coordinator or a parenting coordinator decision maker, be assigned to your case. That gives you a third person to kind of mediate between the two of you. In fact, I communicate between a lot of my co-parent clients, and I'm their primary way of communication. And if you have questions about parenting coordination, how to get one, what they can do, how it works, feel free to either comment below or go to my website that is included in the link on my profile as well. Then the third way is to go to court. And again, this is, if the first 2 have failed and you still aren't getting any responses to something you really need discussed, addressed, figured out with respect to co-parenting, you can go to court. I have touched on this previously, but having the court tell your co-parent, ex, whatever he or she is, that you have to pay child support, or tell them that you have to allow visitation, or say that, I don't know, the vaccination question is kind of tough. That's kind of an iffy one. But if you need the court to restate what needs to be done to your co-parent, you can always go back to court. The case number stays the same in most states, and you just go back and file a motion requesting assistance. There are 2 types of motions that I've mentioned before. One is the motion to compel, and motion to compel is essentially asking the court to tell the other person to do what has already been ordered. So if child support was ordered, pay it. If parenting time was ordered, allow it to happen, or whatever might have been ordered before. That's a motion to compel. Then there's a second motion, which is a motion for contempt, and that would usually be filed when everything has been exhausted, but that is a motion for contempt of court. And if the motion to compel, the court orders it again and then they ignore it, then a motion to compel would be appropriate, saying, okay, you've ignored me twice, being the court, and now you get to go to jail for not following the orders. So I will be doing more on each of those type of motions. Follow me and you'll see that.